This is not a drill. This is a five-alarm fire for the American legal system. From a constitutional perspective, what we have just witnessed is one of the most alarming and, frankly, one of the most unpredictable political storms in recent memory. Within mere hours, not days or weeks, but within 24 hours of a federal judge making the unprecedented call to fully unseal critical classified evidence, documents that were deliberately kept locked away from public and political view, the U.S. Congress erupted. The reaction wasn't tempered calls for more committee hearings. It escalated immediately and decisively. Members of Congress, individuals with profound legislative power from both sides of the deeply polarized political aisle, publicly demanded nothing less than the immediate arrest of the former president, or current president in this context. Now stop for a second and absorb the magnitude of that statement. This is not typical Washington drama. This is a true institutional crisis, and the rare bipartisan alignment signals that whatever was contained within those sealed files must possess a level of undeniable severity that has literally fractured the tribal loyalty of modern American politics. When lifelong rivals agree on such a drastic course of action, every American must pause and ask why. In this deep dive, I will walk you through the precise sequence of events that brought us to this extraordinary moment. What was the legal context of the unsealing order, and what is the legal distinction between simply retaining classified documents and willful obstruction? How did this single judicial action dismantle the careful, long-term political strategies of both the Department of Justice and the White House? And most critically, what is the ultimate legal and political fallout of this event? And how does this crisis of accountability reach directly into your life, affecting things you care about, your tax dollars, the stability of the markets, and your fundamental trust in the fairness of the legal system? I'm Daniel Kershaw, an independent legal and political journalist. My role is not to support any campaign or political party. My commitment is solely to the facts, the Constitution, and providing you with the necessary context to understand these complex events. Stay with me here because this is the kind of detail that changes the narrative from just another scandal to a true watershed moment in American history. Now let's begin with the biggest question this crisis poses. When the authority of the court is openly challenged and compromised at the highest levels of power, how much longer can ordinary citizens truly rely on the legal system to uphold justice for them? The current political and legal firestorm represents the apex of the investigation spearheaded by Special Counsel Jack Smith. The initial scope was focused on the retention and handling of classified documents after the individual left office. We know the charges are severe, covering willful retention of national defense information, multiple counts of conspiracy to obstruct justice, and the serious felony of concealing documents during a federal investigation. But before we go any deeper, we must clarify what the institutional risk is here. We are discussing this scenario while the individual is actively serving as president in 2025. This is not a historical case study. It's a living crisis that forces the entire federal government, from the Oval Office to the halls of Congress, to operate under a suffocating cloud of profound legal and political uncertainty. This dynamic instantly elevates the scandal from a past misdeed to an active threat to the function of the executive branch. The factual basis, as established by prior court findings, is that the National Archives repeatedly demanded the return of these documents, with those demands beginning as early as May 2021. The charges themselves allege a willful and prolonged scheme to conceal. But for months, the most damaging evidence, the key to proving intent, remained shielded from public view by federal judges. This secrecy meant the American public was flying blind, unable to grasp the true scope of the alleged violations. And this is the institutional game-changer detail that most people missed. Typically, the Department of Justice, DOJ, maintains strict control over its investigative work, invoking grand jury secrecy and national security protections. Yet, around January 2025, a crucial shift occurred. The DOJ itself began to initiate the process to disclose Special Counsel Smith's classified report to Congress. This decision by the Justice Department to essentially volunteer its most sensitive findings to Congress is anything but standard operating procedure. It signals that those at the top of law enforcement believe the findings were so significant, so foundational to public trust and national security, that Congress's oversight function demanded immediate disclosure. And subsequently, the federal judge made the ultimate decisive ruling to fully unseal the most critical evidence. When a judge unseals files, they aren't just releasing paper, they are revealing the prosecution's central theory, the expert analysis of classified markings, the timeline proving willful deceit, and crucially, the documentary evidence proving motive and intent, the legal core that distinguishes a careless mistake from a deliberate criminal violation. The unsealing was the political equivalent of tossing a live grenade into the center of Capitol Hill. The moment those files were publicly exposed, the meticulously controlled process envisioned by the DOJ and the White House was obliterated. What was supposed to be a carefully managed release of information evolved into an uncontrolled, immediate public reckoning over classified materials that were meant to remain secret. The ensuing reaction from Congress has been described by veteran observers as unprecedented. Within a single 24-hour cycle, the political conversation instantaneously escalated from measured calls for accountability to the ultimate demand for immediate criminal action. We must dissect the profound implications of the two key statements that define this moment. Representative Jamie Raskin, Democrat, the demand for immediate justice. Raskin, a senior member of the House Judiciary Committee, was unequivocal in his public statement. The Department of Justice simply cannot just stand by and do nothing if there's legitimate criminality involved here. This is more than a partisan attack. It is a profound declaration of non-confidence in the executive branch's commitment to self-policing. It's an ultimatum to the Attorney General, signaling that Congress will not wait half a decade for lawyers to debate jurisdiction while the country faces an alleged ongoing threat to its legal institutions. Raskin's position asserts that if the evidence is as damning as it appears, the DOJ is legally and morally compelled to act decisively now. Senator Lisa Murkowski, Republican, the supremacy of principle. Her statement is arguably the most politically stunning because it represents a complete breach of the current political loyalty code. She declared that sealed documents simply cannot conceal corruption. The American public deserves the absolute truth no matter how high up the chain that corruption reaches. If you are still with me, this next part is the detail that truly changes the political calculus. When a Republican senator known for her measured approach publicly breaks with the deep-seated impulse to protect the party and publicly asserts that institutional integrity is more important than team loyalty, it is the clearest, most undeniable signal that the evidence is irrefutably and gravely damaging. In today's hyper-partisan environment, you don't utter those words unless you have reviewed the materials and found the gravity of the alleged conduct so severe that party loyalty must be sacrificed for the sake of institutional integrity. This is the moment where the political establishment is forced to recognize that the crisis is about the system, not the team. The core of this crisis now rests with the legislative branch. Congress holds the evidence and must confront a profound political and constitutional conundrum. Their immediate options are clear: referral to DOJ, formally send the findings back to the Department of Justice for an accelerated, definitive criminal prosecution decision; independent investigation, launch their own sweeping investigation, compelling witnesses, and demanding testimony to build a public record of accountability; impeachment proceedings, initiate the process to remove the president from office, a procedure that requires time and significant political capital; inaction, do nothing, hoping the crisis will politically resolve itself over time. But there is one undeniable truth. Congress can never choose the option of inaction. The evidence is now public. The demands for action are bipartisan. If Congress allows this event to pass without a serious, visible response, they send a devastating political message that the government is willing to tolerate severe alleged misconduct by the president. This level of institutional tolerance would be a political disaster in the next election cycle and would permanently damage the credibility of the entire legislative branch. The resulting action, whatever form it takes, is guaranteed to overshadow the remainder of the current presidency. Every press briefing will be dominated by this controversy. Every policy announcement will be viewed through the lens of this legal crisis. It will make effective governance an almost impossible task. And if you look at the historical precedent, this pattern, where a sitting administration is paralyzed by external legal threats, has historical parallels, most notably in the final years of the Nixon administration. The difference here is the rapidity of the congressional reaction and the bipartisan nature of the demands, which suggests the political system is reaching a breaking point much faster than in previous crises. This is the long-term rule of law concern. If the trend of the executive branch openly challenging the authority of the judiciary continues, the long-term prognosis for the American system is bleak. A system based on checks and balances requires respect above all else. When that respect is publicly withdrawn by the highest office, the courts lose their teeth. This is the ultimate danger, a judiciary stripped of its power to enforce the law against those who hold power. Final thought for your input. Considering the gravity of the unsealed evidence and the immense pressure now on both the DOJ and Congress, what specific legal constitutional mechanism, outside of a political process like impeachment, do you believe is the necessary institutional response to definitively restore public confidence in the separation of powers and the rule of law? Please share your reasoned perspective in the comments below. The convergence of a federal judge's unprecedented unsealing order, the resulting immediate bipartisan political shockwave on Capitol Hill, and the ensuing calls for the arrest of a sitting president, is without question one of the most defining moments in modern American constitutional history. It has decisively shattered the illusion that political loyalty can always serve as an impenetrable shield against serious alleged legal transgressions. This event confirms that when evidence touches the core integrity of the nation, it possesses the power to transcend even the deepest political trenches. It is a critical chapter that will not only shape the remainder of this presidency, but will fundamentally redefine how America discusses the limits of presidential power, the absolute necessity of institutional independence, and the ultimate supremacy of the law for generations to come. If you value this kind of deep, independent, and fact-based analysis on how court rulings and political decisions directly impact your finances, your freedoms, and your foundational sense of legal security, please make sure you are connected with my channel for all ongoing updates and analysis. Thank you for watching.